Thank you, Michelle, for having me. I think the first thing we need to do is to contextualize the idea of expropriation as a concept. Expropriation on its own is not a new concept. It's globally utilized. It is essentially a tool that the state uses to acquire land or property for public purposes or in the public interest. So that has pre-existed since time immemorial. It's a Roman Dutch law concept that we've adopted in South Africa. So I think the first thing to say about that is that expropriation is intrinsically linked with compensation by way of definition. Now, the ANC government, when it came into power, had previously stated time and time again that expropriation without compensation was not part and parcel of the ANC policy as the ruling party. We saw a change occur in the Bulelwa conference of the ANC National Conference in Bulelwa in 2017, when for the first time the ANC made a resolution that expropriation without compensation must be explored, taking into account food security and agricultural productivity and so forth. Then that culminated into a motion that was passed in Parliament, led by the EFF, on 27 February 2018. And that motion that was passed by the EFF at the time has culminated into the day that we have today. And as I stated to you, yes, there was a turn in policy, from the initial 1996 policy on land to allow for expropriation without compensation. So on one hand, you have the ANC resolution that predated, in fact, the EFF tabling of the issue in Parliament. The EFF then, 2 months later, tabled this issue in Parliament, and what we're having now is the crucial issue to realize is that expropriation without compensation was never part and parcel of the ANC policy until the 2017 resolution. But also secondly, and I think more fundamentally, is that expropriation without compensation is not the sum total of land reform. It is only but a tool that the state can use, amongst many others, to try and accelerate the objectives of the land reform program and in fact, to live up to the national policy on land of 1997.
I mean, the existing land policies that we have in the country, Bulelwa, the still unresolved in many ways question of land in our country, we can see the results of that, don't we? And it manifests in many ways. Farm murders, we can see it illustrated by illegal land occupations, rising evictions, and the list goes on and on.
Absolutely, and this is precisely the idea that I'm putting forward to say, just dealing with expropriation without compensation, whether or not it ends up being passed in Parliament, it's not going to be the magic bullet. We have an overwhelming issue that over 65% of South Africans are urbanized and live in urban areas, and yet we don't have an urban land policy. And this is where we see landlessness. This is where we see informal settlements. And secondly, we have an issue of over 80% of our population in South Africa do not have legally recognized rights or secure rights that will ensure their tenure on our land. The third thing is we have still not determined what the future of South Africa should look like in terms of land ownership patterns. And what does it mean? That means, do we envisage that every single citizen will ultimately become a landowner, or are we looking at something, other than, where there is, for example, state custodianship or leasehold? So all of those questions, for me, are questions that are glaring, that if they are resolved, they will have the effect of actually moving the land reform agenda forward. And I think the overemphasis of tweaking wording within Section 25 of the Constitution is, to me, receiving much more attention, resources, and focus than it needs to. I think there are lower hanging fruits that can be implemented today and that will have a result in tangible results for a largely black population that has no stake in the land question in our country.
I mean, does today in any way go to resolving or addressing, because the land question itself has many facets, doesn't it? Does today go any way in addressing the historical dispossession of land in our country?
That's an interesting question, because the outcome, let's first ask ourselves, what are the likely outcomes of today? A, you could either have Parliament voting for the current proposed wording of Section 25, or you will have a result that says there is no 2/3 majority, and in the extreme, you might even have litigation that ensues from this process. So the parliamentary political process will not have a direct impact on what we're trying to achieve, especially if regard is had to the fact that even before we talk about this amendment, the state has not even tried to use its expropriation powers. Yes, there's a debate around whether or not this amendment was necessary and whether it wasn't. I think we've gone beyond that. I think we all understand, or at least from my perspective, that the amendment comes as a result of the fact that expropriation itself is intrinsically linked to compensation. And what this amendment tries to do then is to make it acceptable in law for expropriation to happen in certain circumstances and where you don't have to pay market value for it. So there is legitimacy in the argument that in the last 27 years, the methodology that the state has used to gain land for land reform has been on market basis, it's been on willing seller, willing buyer, which is actually not what the Constitution provides. The Constitution actually allows the state to be able to do so, lower than market value, taking into account things like the history of the acquisition of the land, the current use of the land,